first case for the morning is Petty versus City of Lorain. Each part will have 15 minutes to present the arguments. Since you're the only person arguing today, we'll have no rebuttal time, of course. We'll just make your 15-minute argument. But when you come up, please make sure you stand behind the podium, introduce yourself, please speak in loud voice so we can hear you well. Then we're also recording. We want to make sure the recording picks up whatever it is you're saying today. We read your brief. I don't think you'll have any victims or children in this particular case, but if you were, refer to them by initials or some other way of identifying them. And we have read your brief and are ready to proceed whenever you are.
Your Honors, may I sit down? I have problems with my legs.
You certainly may.
May I adjust the microphone over?
Will that adequately take care of it before we have a...
I don't think we need the microphone.
Okay, I think we're okay without moving the microphone.
Oh, okay, I'm sorry.
If that's the case, no problem. Please, understood. Thank you for letting us know. Please
All right.
be comfortable in your argument.
Thank you, Your Honors. Your Honors, on behalf of Mr. Petty, the appeal in this matter has to do with a 12B6 dismissal of his complaint under the Open Meetings Act, Ohio Sunshine Law. And I appreciate the fact that you've read the brief. And I'm going to ask the court, to just agree with, the reasoning behind this law so that we can have, the sunshine, is the best disinfectant for corruption and all kinds of other evil things that humans can accomplish. Okay, so what does Mr. Petty do? And when we look at, the judge says that, well, it was just a hodgepodge conclusionary allegations. And I have to really object to that. How can he even say that? When you look at, and you start from page, paragraph 63 through 82 of the complaint, every one of those paragraphs is linked, okay, to the actual footage of what was going on the city council floor, okay? I can't get any better evidence and descriptiveness of what happened on the floor of Lorain City Council during a public meeting.
Now, going through the detailed paragraphs you have where you talk to the specific meeting that took place, and you mentioned specific council people doing stuff on certain days.
Correct.
The court found there were 5 of the council members that I think 5, but a number of council members that you didn't have a specific allegation that they had done anything on those days. Do you agree with that finding by the court?
Absolutely not. The council itself is to be governed by the Sunshine Law 121.22. It's also supposed to be governed by their own rule, which is Article 3, which says they will abide by and obey the Sunshine Laws. And so the people that are sitting there, watching all this stuff go on, and they don't object, they're responsible to enforce their rules. And they just can't sit by mute, and that's what they did. And for the judge to say, well, that's okay, error by omission is as bad as commission, no, that's what I'm arguing. You see what's going wrong, you need to stand up and say, hey, quit texting, quit whispering. Nancy Greer was the clerk.
Is texting and whispering a violation of the Sunshine Law?
Absolutely, ma'am. And in fact, the Ohio Attorney General has issued booklets that describe that as being a violation of the Sunshine Law. In fact, Mr. Petty just came back from a seminar that was put on by the Ohio Attorney General, and that was one of the things that he did. He even took a screenshot of that and sent it around to all the council people to educate them, okay? And what we have in this case is apparently the Judge Rothgary, whose law clerk is now Judge Kobasher, okay? They don't see it that way. They don't think that Sunshine Law is important, that you can whisper, you can text, you can email, you can do messaging. There's all this electronic stuff that they can do now, which is all secret. You can't get it in the public record. And Nancy Greer was the clerk. Brianna Dahl, she's the clerk now. But the clerk is, hired by the council. Okay, her hands are tied. She can't stand up and say, "Hey, council person X, Y, Z, you are violating the law." They'll fire her. She serves at the pleasure of the appointing authority. They set her pay. Okay, so when you ask her, "Hey, what's going on here in this public meeting? What was said?" She says, "I have no idea. I don't know. It isn't available to me to know." But there's got to be limits on what you can demand of the clerk. you know, and the council president is sitting up there, you know, and he's not demanding anything. The law director's kind of timid, sometimes he says something, sometimes he doesn't, but there's no, you know, you can't do this. I mean, you had people taking calls or questions from people that weren't even in the room and not telling us who they are and then ask questions. Okay, so, you know, when everybody else, Mr. Petty and others from the audience, when they stand up, they have to say, my name is Mr. Petty, this is where I live. They have to identify themselves before they are permitted to ask questions. So what we have in this case, Your Honor, is the city blatantly, and it starts, you know, our complaint starts about July 6th and runs through, you know, about 6 months. And it's like nobody's stopping it. It's systemic, I should say, these violations. And so what we really need for you to do is to say, hey, look, under our 12b6 standard, you know, had you even looked at these hyperlinks, which I can't believe, you know, I can't get it any better than the actual performance. And the actual performance was listed and available in the complaint. So all I had to do was click on it or type it in, and boom, they would have exactly what paragraph 63 is complaining about, all the way through paragraph 82. They would have all the visual evidence of the violations of the Sunshine Law. Now, as a lawyer...
You don't have any connection to what those conversations could have possibly be?
Well, of course...
Doesn't it just turn into a fishing expedition at that point? If it was,
what do you mean fishing expedition? First of all...
Because there'd be discovery involved, and then you could say that you could get their phone conversations and things like that.
How do I want to say this, Your Honor? Respectfully, it's presumed prejudicial to the public and to my client.
It's presumed prejudicial because somebody was text messaging?
Yes, because it's secretly text messaging. They didn't give it to the clerk of court so she could make a, you know, she's the records custodian. She has an obligation to have a complete record of everything that happened at that meeting.
So your view would be if one of the council members texted a family member saying, I'll be home at 9 o'clock tonight, that have to go in the record?
Yes, and let me say this, you know, this is not a joke, okay? What if they call it, what if they're doing things, you know, to have, you know, there's serious business being considered by the council, and they're telling their wife, hey, cook sauerkraut. You know, what's that tell you? The public needs to know that during the intensive debate that's supposed to be happening, Representative X, Y, and Z don't give a damn because they're talking about football games or what they're going to bet or where they're going over the weekend.
Is that a Sunshine Law problem? Is that a problem?
Yes, if they don't put it in the record, if they're goofing off, hey, it's like at school. Why does the kid get his hand slapped?
Specifically, what does the Sunshine Law require council members and things to do as far as evidence? As far as what happened before the council?
An accurate and complete record of what is accomplished and discussed at the public meeting. That's what's required. And so, you know, they can tell you, well,
Discussed by who?
It's required
Any
by...
individual council member? Any council member to a other council member to the community? What discussion?
Yes, all of it, everything. One council member can't talk secretly to the other about what they're doing, what they want done. It's got to be public. The public needs to know. It has to be recorded, and it has to be written down so that the public can read what happened at that council meeting. And by going secretly through emails, text, whispering, nobody knows. You'll never know. Unless you're Karnak the Great, you know, like Johnny Carson. Oh, you know, and then you're going to divine the answer somehow. You're never going to know. And the standard that the trial court said, and Judge, let's get back to what you had indicated to me. How am I supposed to tell you what the question is? How am I supposed to tell you? I don't know, because it's an absurd standard that was written by this trial judge. I have to tell him what is being secreted. I can't know what I don't know. I mean, and that's the standard that he gave to me in my pleading. First of all, I don't want to look at what is actually happening. It's just a hodgepodge of garbage that you threw in that complaint. Conclusory allegations. Oh my God, come on.
Counsel, are you arguing straight off of the Sunshine Law statute itself, or is there some case law that you point to for your interpretation?
Well, yeah, I've got case law in my brief, but yeah, the statute controls.
Of course, specifically, however, what case law have you cited that supports the proposition that every text, every utterance, every, every single thing that is, that happens in a council meeting needs to be recorded?
Well, I think I would go to the Ohio Supreme Court, and I would cite you, let's see, Hanson versus Guernsey County, 65 Ohio State 3rd.
Does a publicly elected body have any kind of, does that impact this? Is there any kind of presumptions that are applied to that publicly elected body?
Well, the publicly elected body is presumed to follow the law. That's for sure. Until it doesn't. Okay? So when they start doing all the secreting, public discussion, or hiding what they're talking about to other council members of the public, then they're not following the law. They're not following the law. I'm trying to find the Ohio Supreme Court case on the fact that you're not allowed. On page 23, I believe, of our original brief, there's a series of laws that talk about what the requirements are. It talks about, clear and convincing evidence. I don't know how much better evidence I can get, man, than to send you, the exact videotape of the violations that are alleged in the complaint. I just don't understand how it can get any better than that, unless you were there in person and observed it with your own eyes.
So if I hear you correctly, you're saying that there is a presumption, and then the evidence you presented overcame that presumption of regularity, or that they're behaving in accordance with the law.
Not only did it overcome the presumption, it demonstrated the violation of the open meetings laws conclusively. If this was a criminal case, I'd tell you beyond a reasonable doubt. I mean, you actually have them on, if it was a criminal, you'd have them on tape, actually committing the acts that the Ohio Attorney General says is illegal and you're not supposed to do. It's a violation of the law. And why does it have to go on, for months and months and months? This is not nothing that was secretive, My client complained and about it. The law department, who chose not to be here today, okay, but they have representatives here. Why? Why can't you guys speak up and tell them conform to the law? Conform to your own rule, Article 3, that you will follow the open meetings laws. I mean, this case needs, to be reversed by you, or it needs to be sent back to Mr. Rothgary and say that you made an error. But you think, you better tell him, what his error is, because obviously he isn't going to do it on his own, because he threw me up here for the first reason, for no legal reason, did he throw our case out of court. None. And I think there's also
You get you have about a minute and a half left in your time.
thank you.
You're welcome.
Basically, that texting, unrecorded, unauditable, invisible, and private secret communications demonstrated in the plaintiff's complaint are not exempted under Ohio law. On the reply brief, page 9, presumed harm, prejudice those who brought the action. Injunction should issue against such illegal behaviors.
And counsel, I will note your time is up if you'd like to briefly conclude.
I apologize, Your Honor, I couldn't get you the case.
That's okay, we appreciate that. And if it's in there, we'll certainly review your briefs again and review those cases.
Thank you, Your Honor.
Thank you. And again, thank you for your presentation, counsel. The court will take the matter under advisement and issue a decision in due course. The court will mail a copy of the decision to you on the day it's released, and the decision can also be posted on the wall, posted in the High Supreme Court.